We are going to go ahead and get started with our second program for this afternoon. It is Effective Legal Writing, Formulas for Success. And now that you've learned about tips and tricks for oral communication, let's start to learn about strategies from Professor Beasley for legal writing. She is an emerita professor of law at the William S. Boyd School of Law. She's taught legal writing for 40 years and has been the president of the Legal Writing Institute, chair of the ABA's Communication Skills Committee, and president of the Association of Legal Writing Directors. Professor Beasley understands that busy legal writers often have a short amount of time to digest, organize, and present complex legal information. And today, she is going to teach all of us how to use heuristics or formulas to write legal arguments in ways that will meet the reader expectations and fulfill the reader needs. So please help me welcome Professor Beasley.
Good afternoon. I also want to say I've enjoyed being here. This is my first trip to your fair city, and although this hotel is apparently a Pepsi hotel, I've seen my beloved Diet Coke around, so I will be able to get some soon. So any flaws of my presentation, I had Diet Pepsi for breakfast instead of my usual Diet Coke, so you can just be aware of that. Here is the outline, what I'm going to talk about. I need to tell you one thing about me before we go any further, and that is my hands shake all the time. I have a nerve disorder called benign essential tremor. It is not because you're near. My hands shake worse if I'm feeling like any of the seven dwarfs, if I'm sleepy, grumpy, bashful, dopey, any of them. So just be aware. They tried to give me a lavalier mic, but I had sort of an almost scarring experience with a lavalier mic when I did a CLE in Cleveland once. I was doing an all-day CLE, and at the first break, I went to the bathroom, and don't worry, this is going to be too much TMI. I went into the bathroom, and I went into the stall, and I did what one does in a bathroom stall, and I came out to wash my hands, and there on the mirror above the sink was a sign that said this. That was a little distressing to me because I had already made all my ambient noises. But I will note that because I have a big mouth, I did not have a lavalier mic on it that day. But I am sort of terrified of them, to be honest, and this is one of the reasons why. I hadn't planned to tell you this story, but this is a free lesson. Number one, give your audience information when and where they need it. That sign should have been on the exit to the room, or even on the exit from the podium, so they don't, man, what a bunch of losers I'm talking, It needs to be where your audience needs it. So that's lesson number one. I like to distinguish, and I don't know if other people use the labels this way. These are the labels I use. I distinguish between legal writing and legal drafting. Legal writing, I say, is writing that is about the law. It's trying to explain the law. Here's what I want it to be if you're writing a brief. Here's what I think it should be. Here's something that's a big gap in a law review article or something like that, or if you're writing to a client. Let me explain why your case is going to go the way it is. In contrast, I would say legal drafting is law. Obviously, if you're writing statutes, those statutes are the law for the relevant jurisdiction. If you're writing a contract, that contract is the law for that business relationship. A will, that will is the law of that person's estate. And there are a few things, and I'm sure I'm only listing a few of the items on each side, that I think fit into both categories. Just out of curiosity, how many people do primarily legal drafting? Okay. And the rest of you primarily legal writing? How many don't raise your hands and things like this? Okay, all right, as I think we've discovered. Okay, so I do want to talk, I know you mentioned behavioral economics. I know behavioral economics is recent in my lifetime. For some of you, it's your whole career. But the sort of old theory was that we would all be perfect, rational economic actors. They always talked about rational economic man in the old days. And that we would all do what was best for our financial well-being. and we would always make good, rational economic decisions. But the behavioralist looked at how did people really behave. And sort of a couple of classic examples of behavioral economics. If you go to the cafeteria every day to get your lunch and the desserts are at eye level, you're going to get more desserts. If the vegetables are at eye level, you're going to get more vegetables because that's just, you see them more, you're going to interact with them more. The other classic example is that if your company has a 401k program, there are two ways to set those up. One is everybody gets into the 401k when they join the company. They can opt out, they can change the amount that goes in, but everybody is automatically enrolled. The other one is we've got this wonderful 401k program. You may opt in if you so choose. Guess which employees end up with more money in the 401k when they retire? This group. Because we're lazy, we're busy. Oh, but just this month I need that extra money. Next month I will start my 401k. So when it comes to legal writing, I think that a lot of us have, when I wrote my textbook, and I don't have like I do have a textbook if anyone wants to, good Christmas gift, but when I wrote my textbook on appellate advocacy, I wanted to call it The Cynic's Guide to Appellate Advocacy. Because I think that lawyers are dewy-eyed idealists when they imagine their reader. They're imagining someone who's paying just rapt, oh my God, that brief came in, let me have it, hold all my calls. That they are gonna read every word excitedly, and if they don't understand something, they'll reread it until they get it right. And of course, that is not realistic. I think what was really astonishing for my students is like, wait, they read the way I read, and take breaks and skip things and get upset. How many have heard I can't remember the name of the writer, famous writer who said, I try not to write the parts that people skip. That is horrible advice for a legal writer. Horrible advice, because of course your readers are going to skip around in your document. That is the way people behave. Well, what I want to talk with you about today is how to write in a way that they skip the parts they don't need and find the parts they do. Because that is realistic with the way readers behave. So one of these big concepts in behavioral economics is called satisficing. I was so excited, I was watching an episode of Big Bang Theory, and they talked about satisficing. It's like, ooh, I don't know any of the physics, but this was a word I knew. And what it is, there's the citation. What it is we do not do everything the perfect way. We do not explore all the options. Anyone ever been to the Cheesecake Factory? Anyone ever read the whole menu at the, no, okay. If you don't know, that is the war and peace of restaurant menus, is the Cheesecake Factory. Now, if we were not going to Satisfice, we would read that whole menu. We would consider how many calories do I need? How much money do I want to spend? What's the nutritional content I'm looking for in my food? But we don't, we Satisfice. We think, what is good enough? That is how we cope with what we're reading. And I'm going to show you an example of excellent satisficing. So we've got 3 versions of a recipe here. This is in your materials, and by the way, this is a real recipe, and it's very good. We make it most of our holidays in my family. Here's version A. Here's version B. Version B has the history of the recipe as one of the first headings there. And here's version C. This is like when you go on the internet for a recipe and they tell you about their trip to Tuscany before they actually give you the recipe. So that's like this one. So, which version would be hardest to cook from? I am going to ask for hands. How many think A would be hardest? How many think B would be hardest? How many think C would be hardest? Of course. Of course. And A and B, I will say, are almost indistinguishable. So if you are getting ready you want to make this recipe and you come across this heading that says, history of the recipe, what are you going to do? Skip it, absolutely. And that's fine. I would do the same, but then maybe the oven's not preheated yet. Oh, that's interesting. Okay, I might have time to read it. But I'm going to Satisfice. What do I need? What's good enough to get me through this information? I will note that I had been teaching for about 20 or 30 years before I realized how much legal writing is like recipes. That our readers have very high expectations for how things will be organized and presented, what will be in it, in what order. think about in a recipe. I know when I was first starting to use recipes, the list of ingredients, I would start putting them in the bowl. 4 cups of flour, great. And then I read the details and it says, 3 cups in the bowl and save 1 cup. What? Because I had this expectation. This list is in the order in which I dump stuff in the bowl. Okay? If I were ever writing a recipe and I wanted you to save, I would say 3 cups of flour here and then later another cup of flour, because I know how most people behave about recipes. So we've been talking a lot about empathy. Empathy is the most helpful emotion, attitude, trait, skill, I don't know what we call it, for a legal writer to have, because you want to empathize with the person who gets to read your writing. Okay, what are they going to be looking for? What do they care about? What are they most interested in knowing? I've got to write this and organize this and design this document in a way that they can find that the most easily. So I want to make your life easy too, and not just your reader's life. So I want to talk about heuristics. A heuristic is a fancy word for a formula. If you are solving the same category of problem over and over again, a heuristic, one way to think of it is it's a set of questions that if you answer that set of questions for the same category of problem, you will help yourself accomplish your goal more easily. And legal writing, I think, is heuristics are a very good tool to use in legal writing. And a lot of times, especially deans, tend to be like, oh, formula, well, you're so simplistic. Oh, no. The formula, the heuristic, is the bottom foundational layer. And then you build on that layer as you get to know, when you answer the same question 20, 30 times for 20, 30 different documents, oh, there's this wrinkle that I'm now noticing. So I'm going to change it. My analogy here is, how they sink stuff in the ocean so coral can grow on it. The heuristic is the thing sunk in the ocean, and your coral of knowledge and understanding will develop as you do these things more and more frequently. So the first one we're going to talk about is something I call meow transitions. I know I used to sometimes have my students critique each other's writing, and one of the reasons I stopped was that the comment they put on again and again was, it was good because it flowed really well. And I would sometimes ask them, well, what do you mean when you say it flowed really well? They had no effing idea what that meant. It would be like, well, one word was right after the other word, and then there would be a period and they would start a new sentence immediately. They had no concept of it. But I think what I'm going to talk to you about today, I hope will give you a way to create flow in your documents for your reader. And I'm going to combine concepts from 2 of my favorite legal writing books. First one is Enquist and Oates Legal Writing, this one is called Just Writing, which is, they have a few different books. This is just sentence level, paragraph level stuff. Sometimes people will say they have trouble with their legal writing, and I say, well, is it like the analytical portion, or what is it? And they'll say, no, it's just the writing. Okay, if that's your issue, this is a good book to get. In the chapter on transitions, Ann Enquist, who I surmise is the person who wrote that chapter, talks about 3 kinds. I've changed a couple of the names. Mechanical transitions, that's what I bet all of you first thought of when I said the word transitions. However, therefore, further, in contrast, unfortunately, whatever. Echo transitions or orienting transitions. I'm going to explain these all in a moment, so put that in your pocket for a moment. The second concept comes from one of my other favorite books, which is by a guy named Joe Williams. Joe died a few years ago, so now it's got co-authors. I don't like what the co-authors are doing to the book, to be honest. So I would stick with the 12th edition if you buy it, and you can buy it used online. It's called Style, Lessons in Clarity and Grace. And if you have read Elements of Style and you think it's pretty good, you will spit on Elements of Style after reading this book. Again, I've been teaching for 20 years when I first used it, and I thought, I already understand all these concepts, but the students will bet. No, it's really good. It's got so many, concrete pieces of advice. And one of them is about flow. And so this is what I have labeled the comprehension box. It's in the book. I don't know if they have those top 2 lines on it. But what Joe says is that what is fixed is that the reader will look at the beginning of a sentence for what's the sentence about. Not necessarily the first words, but the first sort of substantive words. They will take that as the topic of the sentence. And they will unconsciously stress words at the end, no matter what we do. We cannot stop that from happening. As far as the bottom 2 boxes, which we're not going to talk about, by the way, I'm not talking about active and passive voice today. Please do not alert the legal writing police, because I think it is a rule that every legal writing presentation is supposed to talk about that, and I'm not going to talk about it. But what is fixed is in English grammar, every sentence has a subject and verb. We can put lots of things in those positions. So those 2 concepts are fixed. As far as subject and verb, it's variable what we put in them. We speed comprehension if we put a character in the subject position and an action in the verb position. As far as I would say context for the reader, because even at the sentence level, the reader is looking for context. If we put short, simple, familiar information early in the sentence, we're going to help the reader's understanding. One flaw is I feel like this box implies, and go find some long, complex, and new information to put it. No, if you have long, complex, or new information, put it at the end. Don't seek it out, okay? So those 2 concepts together are where I get what I call meow transitions. And your goal with meow transitions, or with any good use of transitions, is to prevent the reader having to draw inferences. Because guess what? They won't. They will just go, yeah, and if you're lucky, they'll think, I wish I understood that. They might not even perceive that they don't understand. So here's our classic Socrates syllogism written badly. The issue in this case is whether Socrates is mortal. All chordates die. Accordingly, I conclude that Socrates will expire. A reader reading that is substantively identical to the one we all know so well. But the reader would have to say, I wonder what a chordate is. Is that, maybe look it up. Okay, I guess it's a human being. And then have to figure out that mortality. Mortality, dying, and expiring are all the same thing. So that is too much work for the reader to do. They won't do it. So we've got to use meow transitions to make that happen. To make that flow happen. I've already talked about mechanical transitions. Those are what we always think of when we think of transitions. The next kind is echo transitions. And as the name implies, you're echoing a word or a phrase from a previous sentence or clause. And this is one of the most effective things in legal writing. So if we look at this, the court concluded that Mr. Johnson had violated the statute. Whoops, this conclusion led the court to impose. What do so many of us write? This led the court to impose. And then the reader has to go, this statute, this violation, what happened? So by repeating that word from the previous sentence, we give the reader context. They feel comfortable. This is the flow. They know what we're talking about. They know which way we're going. If we think of transitions, we're telling them where we're moving, or telling them what to feel in the case of, transitions like, unfortunately, sadly, whatever. The third kind I had never thought of before I read Anne and Laurel's book, and I think this is one that's really important in legal writing, and it's what they call orienting transitions. I know when I was in college, one way you could fulfill your phys ed requirement, amazingly, one was by taking billiards, but one way you could also fulfill your phys ed requirement was by taking a course called orienteering. Does anyone know what orienteering is? Don't worry, I won't make you come up here and demonstrate or anything. Orienteering, they drop you off in the middle of the woods with a compass and a map, and they've trained you first. It's not the way they start the class. And then you have to find your way back home using the skills you've learned. And so if you also think of how countries in Europe thought of themselves as Western countries and refer to Asian countries as the Orient, okay? It's about location. So with an orienting transition, you're putting the reader either in a geographical location, which in law is frequently a jurisdictional location, you're putting them in a temporal location with a date or time, or you're putting them in what I like to call an intellectual location. So the plaintiff may argue, or in Pillion the court said, so this is the plaintiff's perspective. This is what the Pillion court said. So that's the intellectual location. So we've got those three: mechanical, echo, and orienting transitions, okay? So now I'm gonna put you to work. You need your handout. If you don't have a handout, I guess it's apparently in your electronic materials, so we can wait 10 minutes while you, no. If there's more handouts at the popcorn table, if you wanna grab one. So what I want you to do is just on the next screen, and on that handout, and I'll just show you the next screen, but example 1 on the handout. Okay, it's just 2 paragraphs. I want you to go through those 2 paragraphs, and you can even skip the first sentence. But for every sentence after the first, try to identify any transitions that you see. And here's the list of them: mechanical, echo, or orienting transitions. And you may talk with a neighbor, as I would say to my students. Who needs more time? Yeah, I need it, but I'm not going to take it. Okay, that's fine. All right, so let's look at these 2 paragraphs. The first sentence I said you don't need to mark up, even though you might say even though is sort of transition-ish. Even though the council was not required to consider alternative sites, it nevertheless did so. Okay, what word or words are the first transition you see in the next sentence? Shout it out. We've got the council right away. The first 2 words are echoing the council from the previous sentence. Any other words that you might have seen that could provide an echo transition in that second sentence? Alternative sites. Thank you, good. Alternative sites, we've got there again. That's a little later in the sentence, but not too late. Okay, and now notice this is a great example of putting complicated information at the end of a sentence, including a comprehensive point-by-point evaluation of the Valley site in comparison with the 2 potential sites considered to be the next best. Okay, next sentence, first transition word, just shout it out. Weighing, what is that echoing? Except that would require the reader to figure that out. I guess what they were doing is weighing it. However, what's the word before the word weighing? After, exactly. We've got a mechanical transition, or you could say an orienting transition. We're putting them in a time, right? It's also a classic mechanical transition. Don't worry if you can't decide which one something is as long as it's there. What's the next transition you see in that sentence? This evidence, great. And that is a classic, whoops, yeah, I'll just leave the council there. That is a classic use of a hook word. This, that, these, those, the. So again, don't say after weighing this, say after weighing this evidence. One of my daughters had a writing teacher who told her that people using this without a noun after it was his pet peeve. So she used Control F every time before she turned in a paper and searched all her thises and fixed them. She got an A in the course from that alone. And we see the council again found that none of the alternatives was preferable to the Valley site. Okay, next sentence. What's the first transition word you see? Petitioners. Petitioners. We're going to take the petitioner's point of view. Next transition. I bet everyone got this one. 4 words? On the other hand, exactly. And then we've got the council again. Would have the council determine which site is the best from among what they refer to as the available alternative sites. Okay, next paragraph. What's the first transition you see? This best site standard. And let me say, this is a great technique to use if you have created a label you want to use. I'm going to give you the foundation for this label, and then I'm going to signal this blah, 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 in quotes. I know in an article I wrote about ballot design, I talked about what I call position influence votes, and I was even more obvious. I said, I call these votes position influence votes. If you want to be a little more subtle, as a friend of mine used to say, you would say, these position influence votes can affect the outcome of an election or something like that. But this is a great example of a way to signal a new term of art you're creating. Okay, this best site standard would force applicants and their ratepayers to incur substantial additional costs. Next, and the next sentence. What's the first transition word? Petitioners. Yes, petitioners. Okay. Petitioners claim that the best site standard, there's another one. So we've got the best site standard picking up, echoing that word. Requires a greater degree of precision than the council's own standard. If you want to highlight the council again, that's fine. Last sentence. Yes, unfortunately, that degree of precision. What's your next? One more. It's got a hook word. Yeah, that degree of precision, which we've got in the previous sentence. Okay? So notice in this 2-paragraph excerpt, notice all the echoes. Look at all those echoes, and it makes it so easy. This 2-paragraph excerpt flows, okay? We'll take a look at a different example in a moment. But by repeating words, some people call them dovetail transitions. We've got a word from a previous sentence and being repeated in the next sentence, so it dovetails. That's a dovetail connection between the 2 sentences. I will just note, in trying to do this in your own writing, in early days, if you try to do it while you're doing your first draft, that way lies madness, okay? Much better to write and then look, do I have transitions or not? For example, let's take a look at this first draft. This is example 2 on your handout. 42 U.S.C. section 1332 allows citizens of different states to sue in federal court. The question here is whether Stifel is allowed to show that he is domiciled in Pennsylvania, even though he was involuntarily removed from Ohio to a Pennsylvania prison. Traditionally, to establish intent, a plaintiff must, okay, take a couple of minutes and find transitions in this one. not so plentiful. Not so plentiful this time. Here's what I found. Your mileage may vary. We've got 42 USC section 1332 placing us, an orienting transition, placing us into the language of that statute. Here, you could probably characterize that as either orienting or mechanical. Traditionally mechanical, and a plaintiff. We have no echo. And this, I think, is a classic example of what happens when a writer who knows something really, really well is writing. Because all of this is correct, right? But if you don't know, domicile law and citizenship rules under 1332, it's not going to be very meaningful to you. So here is one that makes the connections. Again, take a couple of minutes and identify the transitions here. All right, my barometer table, are you done? Okay. All right, so again, we've got 42 USC section 1332, and then, we're allowed citizens, blah, 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 blah. In federal courts, again, I would say that is an orienting transition it's an echo transition. Actually, it is also orienting. So sometimes some can fulfill a second role. And then we see citizenship echoing the concept of citizens of different states. It's determined under state law principles which require the citizens to be domiciled in different states. Cite, to establish, next transition, domicile in Pennsylvania, Stifel must show that he is physically present in Pennsylvania and has the intent to remain there. And that's what it's echoed from. Okay. And I've got stifle in here as an orienting transition also. Okay, the next sentence. Stifle is obviously, I forgot about Pennsylvania. Stifle is obviously physically present, and there we've got physically present being echoed. The only question is whether he can be allowed to establish legal intent when he was compelled to relocate. Traditionally, to establish intent, a plaintiff must, I could have a plaintiff underlined as well. Now, I think there's a nice difference between this paragraph and the two paragraphs we did before, in that the two paragraphs we did before was pretty focused on the counsel. The counsel and the evidence were almost all the echo transitions were about that. Not the only ones, but there was a lot of focus on that. This one is sort of like 6 degrees of Kevin Bacon. Citizenship equals domicile, domicile equals physical presence plus intent. Here's what intent means. And you will have both kinds of writing and some that mix it up. So don't think, I need to have all the same echo words or I need to always go in a chain when I'm doing my echo words. You might have any of those. All right? Does this make sense? Any questions before we go on about meow transitions? And let me say, I know meow transitions, that's an incredibly cheesy concept, but I think cheesy is memorable. So meow is my metaphor, and I'm sticking with it. Okay, let's continue. This one is, I talk about because in my advanced writing course, where we did legal writing documents and legal drafting documents, I found in so many of them we were dealing with definitions. How do we include definitions? How do we use them? What do we do with them? And we eventually broke them down into 2 categories, and I don't know, again, if I'm the only one using these labels. The first category is lexical, like a dictionary definition, okay? I use this when I have jargon and I'm talking to a non-legal audience. So I'm going to need to define plaintiff, defendant, motion to dismiss, whatever the thing may be. The second kind that I call stipulative. We're stipulating that this term has this meaning in this document, okay? And I think a lot of times stipulative definitions can be really helpful to the writer and therefore to the reader. I realize that I didn't call them stipulative definitions at this time, but at Ohio State I used to teach 4 sections of appellate advocacy and on 4 different days, and I used to write the actual due dates in each syllabus. And guess what? Sometimes I would mess up and put the wrong due date in one section syllabus. But the papers were always due the day before class. And so I just started putting in the syllabus, paper due at 11:55 p.m. day before class day. So class day was a stipulated definition, meaning the day we have class. And so instead of creating an opportunity for error for myself, I use that term of art. And this is what we do a lot in contracts. So, as I say, we use lexical definitions for jargon and stipulative definitions. First, if they can help you create an effective form contract or form syllabus or other form document. I have my students do a contract with a covenant not to compete, and I say your goal should be to have no specifics in the body, even if in real life you would. So I have them making up a stipulative term for like how far away they have to be before they're allowed to compete, just to get that practice so that when they revise that form contract, 90% of the revision will be in the definition section, okay? The other thing is, and this is I think more useful in statutes, to allow you to use a shorter term rather than a long complicated list or a long complicated definition. One big thing I will say, when creating a stipulative term other than like buyer, seller in a contract, a modifier plus that term is good. It's really important for that term to be intuitively understandable. Okay, they shouldn't have to read the definition to get a general idea of what it means. Okay, you can look at your example. I'm not really going to make you work and turn stuff into me or answer me every time. Some of the examples are because I can't make the print big enough on the screen to be sure that you can see it. But this is, again, an example I've used with my students. Obviously, for those of you who draft contracts, you know that in the preamble and the recitals, you are not using stipulated terms. You're using the party names and what's really going on, because this is where you provide context for what's going on in the contract. But if you look at this and think, well, what are terms I could define that would help the course, the teacher, whatever? And typically, with my students, I would get stuff like, a student is a person who works to learn something. Closing date is the date on which the parties may know, okay? Instead, you're stipulating the closing date is this calendar date. The student is this person with this name and this address. Okay, so those are the sort of obvious ones that we do in contracts. There's our happy face, very nice. Here is an actual excerpt from a statute. I think they've revised it and made it worse, in my opinion. But take a look at this and think, what are terms that are, this is example 5. What are terms that are, or language that is significant to the meaning of this statute? This is when is a dog owner liable for a dog bite? That I could maybe create a stipulated term for. That is more than one sentence, but it just feels like one hellish sentence. So let's take a look. So the first thing I just underlined things that I think we could make a stipulated term. We know this is something about ownership of a dog, some sort of owner-type relationship for a dog, and you get harmed by the dog, injury, death, or loss to person or property. And if you're doing these bad things, you don't get to recover, committing or attempting to commit trespass. And another thing is if you're teasing or tormenting. And then if you are going door to door selling Girl Scout cookies or whatever, the rules are a little different for you, okay? So here is a possible revision. And again, I have this as example 6, not to work on it, but so that you can read it. It's too small to read on this screen, I think, for most of you. And I'm going to say skip to paragraph 2. Except as noted in paragraph 3 below, the legal custodian of a dog is liable in damages for any compensable harm caused by the dog, unless the compensable harm was caused to the person or property of an individual who at the time was engaged in any of the following: committing or attempting to commit an impermissible trespass or a serious criminal act on the legal custodian's property, illegally provoking the dog on the legal custodian's property, or committing or attempting to commit a serious criminal act against any person. We don't have any of those, really fussy details, but we get a really pretty good understanding of what's going on. Now, if you were, babysitting your neighbor's dog for a day, you might, okay, I better go see what a legal custodian of a dog is. And then, of course, the court is going to determine what does it mean to own, keep, or harbor a dog. That's going to be a court determination. But by writing it in this way, there we go. By writing it in this way, that sentence is so much more digestible. And because you used meaningful, intuitively understandable terms, legal custodian of a dog, I get that. Impermissible harm, or whatever I said, impermissible trespass, yeah, I get the gist of what that is about, okay? So when you are doing these terms, obviously people get buyer seller. Those are terms that people get. But you want to make sure the term you are defining is going to be intuitively understandable to your audience. And I will note, for those of you who are thinking, well, I only do analytical writing, yeah, you're right. Most of the time, you're not going to be using these kinds of things in a court opinion. But if you do regulatory opinions, administrative law opinions, I've read admin law opinions where they're essentially like a contract, especially in oil and gas law. Some things I did out in California when I did some CLEs out there. So you might see, if I am writing these really complicated paragraph after paragraph, can I make everyone's life easier by starting with some stipulated terms, by putting them up there and then using them throughout the body. And again, just to point out, we're not going to talk about this, but here is a DUI statute. A person violates this statute if they operate a regulated vehicle with a restricted amount of a regulated intoxicant in their bloodstream. I get what's going on there. I can't drive, essentially. I understand operate a vehicle. I know there's nuance there. But I get the gist of it just from those stipulated terms. And to the extent I want to know more detail, yeah, I just pop up and read those definitions. Okay? Any questions on use of definitions? Okay. I'm going to talk about this concept that I call phrases that pay. And I think this can be a real time saver when you are trying to structure an analytical document. How many of you know the label key terms? Oh, okay. Key terms, like phrase, I just use phrase and pays because it's more fun. The phrase that pays is like, what is at issue? What is language that people are fighting about or could fight about in the language of a rule or a statute or some other rule, okay? So you want to identify possible phrases that pay, and then identify which ones are controversial. So as I say, I think a really good technique you can use to structure your document is obviously first you've got to identify your issues and then identify the rules that govern those issues. Now for each rule that you have to apply, or you have to argue the court should apply, what are the potential phrases that pay? What are things that people could argue about? And then, the important step, what are people actually arguing about in this case? And then for everything that's actually being argued about, okay, I have to hit that. And then we'll talk about when you might have to hit other things, because I've got this other formula here. So if we take our DUI statute and think about that, how do we determine which ones might be controversial? When I first started analyzing this, So the more controversial the issue, the more we're probably going to have to talk about it. And the more abstract the language of the phrase that pays, or the key terms, the more we're going to have to talk about it. If you've got something that says if someone has been convicted of a felony more than 3 times, they are a habitual criminal, okay, I just have to add how many times. That's the very concrete language and probably not very controversial. But if it's what is an owner, or no, owner of a dog is probably pretty clear. What is a harborer of a dog? That's a little more abstract, okay? And so, I thought this was a little too mushy, so I went on to this formula of ignore, tell, clarify, prove. So for every possible phrase that pays, ask yourself, how much should I talk about this? Now, ignore is only an idiot would think. You don't have to say, as a Homo sapiens, Ms. Beasley is a person under the statute. You don't have to explain that. And let me say, a Ford Fusion is a regulated vehicle under the statute. You could probably ignore that one too. But in Ohio, God, it's probably 10 or 15 years ago now, some bozo got pulled over for DUI. No, he didn't get pulled over. He crashed into a tree and they found him. But instead of being in a car, he was on a motorized bar stool. So he's like, ha, 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 you cannot get me. And yeah, dude, that counts. That's a motorized bar stool as a vehicle. But hey, the first time that got litigated in your jurisdiction, you might have to prove that. There might be an argument that the language defining what a regulated vehicle is does or does not count, okay? So let's take a look at these. Here is my little flow chart. I'm proud of the intellectual work that went into this, but I'm also very proud of the physical work that went into creating this on PowerPoint. It was not easy, especially for a shaky-handed person. So I can never make it bigger or smaller, because it would be too hard. But is the issue legally significant? No. Could someone think it's legally significant? No. Well, then don't talk about it. Ignore it. But if they think it's legally significant, then I might have to tell or clarify. So this takes you through the issues. You might not, just as once you identify the issues, just even thinking ignore, tell, clarify, prove, I think most of us get the gist of this. So as I say, tell the outcome of an analysis of an issue if it's not controversial or not relevant to your analysis, but someone might need some clarification. They might not understand, or they might want reassurance that it's not controversial. A motorized bar stool is a regulated vehicle under Vanita's DUI statute. Boom. I always used to tell my students, are there any students here? Any law students here? Don't worry, I'm not going to make you come up, okay? But on exams, a lot of times when people got bad grades, it's because they had ignored what they thought were obvious points. And if they just made it a tell issue, they would have been okay. A clarify is like a tell, except I got to give you a little more factual detail or a little more detail about the rule in order for you to understand why it's not controversial here. So it's just giving you a sentence or two of why this is not at issue in this case. Approved legal issue. I'm just going to talk briefly about these. I've got a couple of examples of my formulas in the handouts, and just sort of FYI, and they're in any of my books. I have examples of this. But in law school, in my day, I went to law school deep in the 20th century. I graduated in 1983. We learned IRAC. When I started teaching writing, we kind of realized that we don't want to start with suspense. I always say suspense is the enemy of good legal writing. So you want to say right away, here's how this issue comes out. So we start with a conclusion. But then we realize sometimes there's a gap between the rule and the application. So if we say human beings are mortal, and then we say Socrates is a man, wait. Are men human beings? Does that count? Now, we know men are human beings. But, human beings are mortal. Human beings include men and women. Socrates is a man. Because Socrates is a man, he's a human being, and therefore he's mortal. So that explanation is a gap filler. So we changed IRAC to crack and then to CREAC. This is why I'm not anti-formula. because the formula starts out simple and then gets more sophisticated. And I noticed my students having trouble when I would say conclusion at the beginning and conclusion at the end, and they thought they would be the same. So my colleague and I, Monty Smith, who I co-authored a couple of books with, we call the one at the beginning the conclusion thesis, and the one at the end the connection conclusion. Connection conclusion I call it because I would find some students would have moved on to the next issue by the time they got to the end. And so if you call it connection conclusion, it's a way to check. Are we still talking about the same thing? There should be a connection between what you say at the beginning and what you say at the end. But I will also say at the connection conclusion, you may also connect it. Does this issue tell the whole story? Now I win. Therefore, phrase it pays is met here, and therefore this court should affirm. So you might be connecting it to the future as well. As I say, I have a couple of what I call my math CREACs or math CREACs, and I have two examples here. The language is very generic. You do not need to imitate the language, but I think it is helpful formulaically for what you want to include in a proof analysis. There are ways you can, this gives you sort of a soup starter for doing this. And I'm not going to give you an example in text. My books are in libraries, so I'm sure you can find one without buying it, but I think these can be helpful for you. Does anyone have any questions about CREAC or CREAC or why do we do that or whatever? That's okay. All right. So we all, and I think this ended up in the wrong spot on your, in the one you got handed out, but all readers need context, all readers need to comprehend, and all readers need to be able to navigate through the document, okay? So you want to be thinking, how am I making that easier? Context, even in non-analytical documents, you should be providing context. I had a student once who was working in criminal court, and he had to give this piece of information paper, that's a new term, this paper with information on it to someone right after they had pled or had gotten on parole, and he would give it to them, and they would always say to him, why are you giving me this? What is this? What am I supposed to do? Why is it on this paper? So for his final project in the class, he rewrote it. And the first thing after the title of the paper was, why am I receiving this paper? Here, and here's an explanation. So think about, what does the common audience for this paper need, okay? In a contract, we know, we give them recital, preamble, whatever. In a memo or a brief, we give them roadmaps. So what I recommend for helping comprehension, navigation, and context, install what I call a template in the document, and they'll give you the elements. Make sure you have sufficient white space. Now your computer is going to try to do that for you. Avoid full justification. We'll talk about that briefly. And then I think most of us are still publishing or typing, designing our documents as if we're using a typewriter. I use typewriters. I learned how to type on a manual typewriter. But there's so much more that we can do with our computers, and we are not doing it. So we'll talk about that a little. Okay, so here's the template. And these are all places that readers are going to automatically be looking for information. They're going to look at headings, they're going to look at roadmap paragraphs, they're going to look at topic sentences, which you might have learned thesis sentences. I call them topic sentences because I think topic sentence on top, okay? And they're going to look at connection conclusions or conclusions. I know I talked to a judge once who did not want to put the result of the case in the first paragraph. And I said, well, what do you do when you read an opinion that doesn't have the result in the first paragraph? And of course, you know what he said? Well, I flipped to the end to see it. Okay, what is your reader looking for? Where should I put it so I can make sure they find it? And it should probably be in both places, right? It should be in that initial paragraph in the court opinion and in the conclusion. Okay, for headings, I am a real fan of substantive headings, and again, I do a lot of teaching to judges, and a lot of courts have headings of background, analysis, conclusion, and that's, wow, now I get what's going on. I gotta tell you, don't be surprised. I know there's a lot of Supreme Court opinions coming out. Here's one of the headings right there for you to see. Unless, I haven't looked at them, maybe they've changed their ways, but the last time I checked, all they give you is a Roman numeral. This is somewhere, I am dividing this into parts for some reason. No, not helpful. Be substantive. This is, again, not terribly helpful. This is more helpful. And I would say this is most helpful. Okay? Now, I'm going to talk one about something that you can do and one that is probably just a crazy emeritus professor's crazy fantasy. The thing you can do is use scientific numbering, which is instead of Roman 1, then the A's, then Arabic numerals, then small letters, then Romanettes, and get out of here if you're into Romanettes, reorganize your life and your writing. But scientific numeration, one of my legal writing colleagues calls it never lost numbering. Think about how we read documents now. You might Control F to find the discussion of a case or statute you want. And if you get to something that is B, okay, I'm in the second part of something. But if you get to 2.2, you're in the second part of the second part. Okay, you get a lot more for your money with that simple change in numbering. It is very hard to do. I automatically default to Roman 1 when I start numbering, and so does my word processor. So you have to really force the situation. The other thing that's my crazy dream is, you know how when you're reading a book and you turn the page physically and there is a heading that tells you the name of the chapter? So you know where you are, especially if you put it down for a while and then pick it back up. What if you clicked into the middle of that section and it said at the top of the page, Officer Perrick did not have reasonable suspicion. 2.2, Officer Perrick did not have reasonable suspicion. You'd know where you are and what that section was talking about. Wouldn't that be fabulous if that could happen? Judges would have to lead the way. So any of you who are clerks, please get on that. Okay, roadmap paragraphs. Anytime you divide something into subparts, please give me a roadmap. Because if I see an A and then an Arabic 1, or a 1 and then a 1.1 with nothing in between, how many parts is this gonna be? I have no idea, okay? So I'm in suspense. Suspense is the enemy of legal writing. Foreshadow your point headings, number the points in the paragraph with actual Arabic numbers. It's perfectly substantively fine to say first, second, third, but your eye goes to the numbers in a way that it doesn't go to the words first, second, and third. And as I'll illustrate, turn it into a list even better because people are scrolling and scanning through documents these days. I also say, especially in the main roadmap for a document, you're probably going to add what I call backstory, which is think about if you are watching a movie and someone comes in and says, actually, they might lean over and say, okay, what's happened so far? Okay, if the law is a seamless web, what part of the web are we looking at in this case? So you're giving context by giving the backstory, and it doesn't have to be terribly long, but it'll usually have an assertion about the writer's case, argumentative if it's an argumentative document, the legal rule or standard, how the legal issue in this case relates, and number 4 is a very rare thing, but sometimes it's useful, the current status. For example, let's say there's a split in the circuits. You might put that in the backstory so that people would know. This one, and then we've got roadmaps. I feel like y'all know roadmaps. Okay, so here is a list of headings from a document. And where you would have, I say umbrella and I haven't defined that term. The umbrella is the backstory plus the roadmap. Okay, so here is an umbrella. So there's the assertion about the issue before the court. This court should affirm the trial court's decision and hold Bert Riegert liable for negligence. Here, and then we're combining a lot of things. Riegert can be held liable because Kroger has established all of the required elements of negligence and because Riegert did not establish that Kroger was comparatively negligent. And then we have citations. Now, if negligence and comparative negligence were sort of new and exotic issues, you might have a sentence that says, to hold someone liable for negligence, a person must prove, da, 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 da. But this is a pretty much garden variety legal issue. Just stating your conclusion with a seaside at the end covers it. And then we've got our elements then we have our roadmap. And notice how it is geographically broken out. So someone scrolling through or flipping pages through will see it and stop and look at it. And in an argumentative document, you are making your point strongly in those roadmap points. So Rieger can be held liable. That's our ultimate conclusion. Each of those is our position on that sub-issue and what we want the court to do. Okay, and you've got the example in your handout if you want to see it in better print. Okay, and often a roadmap can be even shorter. So in the causation element, a plaintiff establishes causation by showing causation in fact and legal cause cite. Here, Kroger has established both of these elements. That's probably a weak roadmap. It could be, Rieger has established, or Kroger has established both, one, causation in fact, and two, legal cause. That would be more effective. But we've got sort of the basic roadmap. So in other words, I don't want you to think backstory has to be this huge thing. It's just what context do they need to understand what part of the seamless web of the law we're looking at here. All right, any questions about roadmaps? Okay, moving on to topic sentences. Topic sentences I feel very strongly about as far as behavioral legal writing. How many of you have ever read the first sentence of a paragraph and yet not completed the paragraph? What madness is that? No, because you read that first sentence like, I don't get how you're going to help me. This is the topic sentence when when the reader reads the topic sentence, that is when they decide, am I going to bother reading this paragraph? Am I saying you want to force your reader to write in a way that your reader reads every paragraph? Absolutely not. But you want to write in a way that first sentence gives an accurate label as to what they're going to get out of that paragraph, okay? So, here's more. We'll look. Okay, this is my worst nightmare as far as topic sentences go. Much better, okay? And think generically. It's very simple to write a good topic sentence. What do I want my reader to get out of this paragraph? What do I want them to conclude after they read the paragraph or understand or believe? Very frequently, when I've edited work for people, Sister Mary Elizabeth, who taught me how to write topic sentences as a junior at Notre Dame Academy, they learned the topic sentence is the first sentence, the second sentence, or the last paragraph. So a lot of times I will find topic sentence and paragraph. Is this breaking up? Is it okay? And I just promote it to the top of the paragraph. So your goal is what should they learn from this paragraph and get it up there, okay? I have this chord. Obviously, you want to signal what the paragraph is about. If you are talking about cases, and it's so tempting to tell them about the case in the topic sentence. I don't care about the Dutile case. That is not this case. I care about what I should learn from the Dutile case. Courts must not admit evidence of prior bad acts when the evidence is highly prejudicial and not needed to establish relevant elements. Period, cite C, Dutile. And then if I need to tell them details about Dutile, that's fine, but not in the first sentence. Because they might say, I don't care about Dutile, skip, and they might not get that important thing you need them to know. I also think so important to frame your point of view. If you want the court to grant the motion, don't write a paragraph telling them how to deny a motion, okay? If you want them to find that they can search, articulate the rule, someone can search a vehicle. It just cuts out, it's so cute. Yours did it too, but. When someone can use it, and if you want them not to find that they can search, here's when someone may not search a vehicle. So framing your argument with that topic sentences. And I think a lot of times people feel like they can't use topic sentences and fact statements, both judges and attorneys, because they feel like the facts should just be objective and I should not be manipulating the reader by using topic sentences. I agree, don't manipulate, but you can honestly frame. And I think there is a tendency to write fact statements, here's what happened, and then that happened, and then that happened, and then that happened. And what is the point of all of this? Here's one that I found in a domestic case, obviously. Parents had multiple domestic disputes about alcohol, including an incident in which father put a gun to mother's head and hit her in the face while the 2-year-old was watching. Very sad, very tragic. What is this about? Is this about domestic violence? Is this about the 2-year-old leaving the house? Is this about somebody getting custody and somebody losing custody? Why not start the paragraph with that information? RG was taken into the custody of Department of Family Services at the age of 2 in 2013. At that time, mechanical transition. Here's what was happening in the home. Detail, 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 detail. A lot of times when I'm talking about effective topic sentences, very little will change in the body of the paragraph. It's just how you started. What is the label I want to put on this paragraph? All right? Any questions about topic sentences? Okay. I promise I'll let you out. Are we past time? Oh, I have till 4:30? Okay. Okay, no, all right. Everyone's like, please say your past time. Okay. Internal conclusions, yeah, end it, and that is a huge position of emphasis. Every item in the template is a position of emphasis. Anytime you have a little white space gap, the reader's attention perks up, not unlike when a judge gets a break for lunch or a snack. And so you want to exploit that. Don't end up on a citation and use headings to provide the transition. Don't do what I call the Nancy Drew thing, which I'll explain in a minute. So there is the sentence that is really the conclusion of this section of the document, buried in the middle of a paragraph. I would take out that whole parenthetical and rewrite it so the ending is really the ending. That's a POW opportunity for emphasis. Second, this is what I call a Nancy Drew conclusion. Any Nancy Drew fans here, the Hardy Boys? They used to write those on purpose to encourage kids to read. So in every chapter, Nancy would solve a problem with or without the help of Ned Nickerson. And then the chapter would end with suspense. Then there was a knock at the door, but then she heard a shout from the next room, you know. Oh, I have to keep reading to find out what, you know. But your reader is not like that. They're gonna read what they need and skip what they don't. So don't say manifestation is an applicable trigger. Next, now we have to know what happened with ANI. No, just end it. Manifestation is an applicable trigger. And instead of reaching forward in your conclusion, reach back in the start of your next section. Because manifestation is an applicable trigger, we must next discuss. So if you think you want to make sure the reader gets that connection, don't do it at the end of part 1, do it at the beginning of part 2. Okay? And especially if you think about a reader who has gone to part 2 from the table of contents, and because that's what they care about, you're giving some nice context by saying, hey, the only reason we talk about this is because we already wrote that manifestation is an applicable trigger. Okay? All right. Next, okay. Remember that you don't have a typewriter. You have an amazing computer at your disposal. So first, full justified text is the one on the bottom. And the one on the top is left justified. How many of you are thinking, but the full justified is so pretty. It looks so much nicer than the left justified. Okay, it does look nicer. If you were going to hang this on a wall and no one ever has to read it, except when the person reads the proclamation, fine, use full justified. Otherwise, left justified. I'll also say every poster, any posting on social media, always center text, so hard to read. Every line starts at a different place. The reason full justified is bad, unless you have very sophisticated kerning software, the spaces between the words are variable. And so the reader, on left justified text, their brain gets going like this. On full justified text, it is like it's uphill. They go sometimes like this, and sometimes down a couple, and then another big one, and then a few more small ones. And it's hard to get your brain into a rhythm. So it's just punishing on the reader to use full justified text. Some of you may have to argue with people at your law firm to let you do this, because I know at some courts and some law firms, the rule is full justified. I give them my phone number, I'll be glad. The other thing, then this is the big one about exploiting what you can do. Here is a paragraph doing a classic thing in legal analysis, comparing the language of two statutes. Most of you say, I know what to do there. I will put them in block quotes to make it easier. Okay, get ready. You could really do that. You could put them side by side and underline the language that you want to compare, because that's going to be the easiest way for them to see that comparison. As I say to my students, sometimes you want to think inside the box. And if those of you who are ever doing consumer documents or things like that, boxes are so powerful. Boxes are so powerful to help the reader see what's going on. All right? And my last thing, and then I will take general questions if we have them, and I think my timing is a little early, but how many of you know about what hard spaces are? Oh, so many. I'm glad one person does, maybe another one over here. If you have a section symbol at the end of a line alone, and then the number on the next line, that section symbol looks like it's yearning. Oh, where is my number? And it is just not effective for the reader. And what if there's a page break there? It's really hard for the reader. So you connect it with something called a hard space. A better label for it would be a connecting space. What you do is you take out the regular space first. That's crucial. A lot of people forget that. And then you insert a hard space, which on MS Word is Control plus Shift plus space bar. And then it's like it's got a hook from the section symbol to the number, and that they together are a word. And I would do that if you do internal enumeration. There are 4 reasons why this is bad. 1, 2, 3, 4. You should do that hard space. The second thing is, how many know how to do keep with next? Okay, keep with next. And I am a WordPerfect fan. I like being able to see what's going on by using reveal codes, but this is something MS Word does better. Your heading, you know how you have a heading sometimes at the bottom of a page, and you know you're not supposed to do that. So what most people do, they'll just throw in a hard return. And then they end up editing it by adding or subtracting a paragraph, and they end up with a page that's like a line long. This keep with next does the same thing between 2 lines that the hard space did with that. And these are detailed instructions. If anyone wants to see it, you can come up here and I'll show you. The third thing is shortcuts. I haven't typed my name on my own word processor in years. I type MBB/ and it spits out Mary Beth Beasley. If I'm working on something and there's something complicated, I create a shortcut for that. I have shortcuts for could, would. The word language I can never type without first typing LanGauge. And so this is a super useful technique. And I use it, I have dozens of these shortcuts for myself. Anything that you have to type multiple times, and even when this is my first spring that I didn't have to correct papers in about 40 years. Anyway, when you, even correcting papers, even though I knew it was a unique problem, I wouldn't be doing it again, but I would be correcting 30 papers, I would create a shortcut saying, you should refer to the plaintiff by Mr. Henderson instead of by the plaintiff because or whatever the comment was, because I knew I would have many students making that same mistake. So it's a really, really useful technique that you should learn. And for symbols, it's a little harder. I'm not going to go through it here, but there it is. So, summary. You want to think about who is my audience and how do they behave? How do they behave? What do they care about? And what I talk to judges about, and you can think of this, especially if you write for other lawyers, in this kind of document, what do you go to immediately? What do you skip? Both of those things should have headings so that they can be found if someone wants to go to it immediately, or they can be skipped if someone wants to skip it. For example, when my students write a motion to dismiss or motion to suppress, of course they have to put the motion standard in it, but I tell them put a big juicy heading on it so the judge can skip it, and then, oh, this case had a wrinkle I didn't expect. They can go back and look if they need to. But what would someone want to skip? Give it a heading. What would someone want to find? Give it a heading. And then these formulas will help you. Here are questions you can ask. I have a little camera there because this is not in the materials, so if you think this might be helpful, you can take a picture of it. I remember the first time a student took a picture of one of my PowerPoints. I was like, oh, okay. I thought it was me. So I will also note, this is, when Rhonda was talking, this is consistent with a lot of what I've read about how our brains work differently with digital documents and hard copy documents, and what I've learned about learning. A really good way to cement learning is focus. So what I recommend right now, whatever you want to remember from these two talks, think about it, focus, write something down, focus on, attach it to some other memory in your head as a way to retain that bit of knowledge. All right, and I have some time for questions, but this is my homage to the French PowerPoint makers, so that. So any questions about anything, including passive voice? Is it okay to leave? Is that your question? Is it okay to leave, Jennifer? If you have a question, you can come up and ask me privately if you don't want to be the kid who said you forgot to assign the homework. Okay? Thank you very much for your attention. I appreciate it.
Thank you much. I just have a quick couple remarks. Again, thank you to our speakers, both Rhonda Murr and Professor Mary Beth Beasley. Again, please do check out their books if you're able. Rhonda Murr's book is Beyond Smart, Lawyering with Emotional Intelligence, and Professor Beasley has several books, including a textbook, A Practical Guide to Appellate Advocacy, along with her co-author, Dean Monty Smith. Thank you all for being with us for today's program, certainly for our other CLEs today. And please, please, please complete the post-CLE evaluations. For any of the programs you attended, we would love to have your feedback on the programs. You can find it in the conference app. There'll be a QR code here on the screen momentarily. It will also be emailed out to you. And then we also ask that you take a few minutes to complete the CLE committee survey. That is also on the app and also will be emailed out to you to tell us what kind of content you want, how you like to receive your programming, so we can hope to provide the best member benefits that we can as a committee and provide you the best programming possible. So with that, thank you for being here. Thank you for engaging. If you have questions for the speakers, come on up. Otherwise, we'll see you at our social events. Have a great afternoon. Thank you.
Check, 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 check. 1, 2, 2, 2. Normally people hold the microphone right about here. Check, check, check. Not quite here.